Get ready to explore a more nuanced definition of the term civil recovery investigation. We'll break down its intricacies and how it fits within the larger context. Here's the definition of civil recovery investigation. The Proceeds of Crime Act, 2002, PC 8/2002, Section 341 defines a civil recovery investigation as 1 in 2, whether property is recoverable property or associated property, who holds the property, or its extent or whereabouts. An investigation is not a civil recovery investigation if proceedings for a recovery order have been started in respect of the property in question, an interim receiving order applies to the property in question, an interim administration order applies to the property in question, or the property in question is detained under PC 8/2002, Section 295. Recoverable property is property which is or represents property obtained through unlawful conduct. And associated property means property of any of the following descriptions which is not recoverable property. Any interest in the recoverable property. Any other interest in the property in which the recoverable property subsists. If the recoverable property is a tenancy in common, the tenancy of the other tenant. If the recoverable property is part of a larger property but not a separate part, the remainder of that property. Hopefully that explained everything you needed. Bit more involved, that definition, so do replay it if you need to.
Thank you for taking the time to understand civil recovery investigation. LexisNexis is your trusted resource for exploring its legal implications, complete with news, Q&As, and actionable practice tips.